In California, a divorce is referred to as a dissolution of your marriage. Dissolution of marriage is initiated by a petition for dissolution. The petition for dissolution is then required to be served on the other party. Most importantly, when you initiate a dissolution of marriage in California, you automatically agree to what's referred to as temporary restraining orders. Those temporary restraining orders preclude you from moving your assets around, from selling them, from hiding them, or from changing any kind of health insurance or automobile insurance. They're referred to as temporary restraining orders. You have to personally serve the other party or have that other party agree to accept service. When the other party agrees to accept service, they are bound by those same temporary restraining orders. Those temporary restraining orders, if violated, can lead to consequences such as contempt of court or restitution of the funds that you have moved and/or attorney's fees for the cost of enforcing those orders. In California, after the petition for dissolution is filed and a response by the other party is filed, the court then has jurisdiction to make temporary orders and to administer the laws of California with respect to your proceeding. That includes temporary orders for support, temporary orders for custody, and other temporary orders considering your assets. In California, there's a fiduciary duty for each party to fully disclose all of their assets and obligations, and that's normally required within 60 days after the case has been, quote, at issue, close quote, which means both parties have appeared in the proceeding by having filed a petition and having filed a response. In California, the earliest possible time that you can terminate your marriage is 6 months after each party is involved. However, that's rarely going to happen if there are issues of property, support, and custody. It will take a considerably longer period of time to do that. Most importantly, California has been a no-fault state since 1970. And what does it mean to be no fault? That means transgressions such as infidelity doesn't count. All you have to allege in your petition or your response is there has been irreconcilable differences, and the court will never ask you what they are. The only requirements to file a petition for dissolution in California is that you have been a resident of the county in which you reside for 3 months and a resident of California for 6 months, which means you can't go to Las Vegas and get a quickie divorce. You have to be here for a while. Your lawyers will guide you through the arcane rules of community property and assist you in navigating. If you reach an agreement, the court will take that agreement and turn it into a judgment, and then that part of your divorce will be over. If there is support in children, however, the court retains jurisdiction in order to modify those particular orders upon a particular change of circumstances.